Commencing my lecture on the important aspects of Indian Constitution, I would like to give you a brief outline of framework in which I will be dealing with the various aspects, the various facets and the circumstances of the Indian Constitution. So in my first slide, a brief introduction of the background will be given to you, that what were the circumstances, what was the situation prevailing at the time when the Constitution of India was framed. Thereafter, the historical background, commencing from the advent of the British rule and up to the independence of India, that is in the year 1947. My third slide will be dealing with the drafting and formation of the Indian Constitution by the members of the Constituent Assembly. My fourth slide will be dealing with the structure, the organization and the hierarchy of Indian Constitution, that how various parts have been properly organized under the heads of articles and parts. My fifth slide will be dealing with salient features of the Indian Constitution, and at the end I will also make a critical evaluation, as we are going to enter in the 75th year since the day when the Constitution of India was finally adopted. So we will be having a critical evaluation that whether we are successful, whether the Constitution of India was successful in achieving the goals, in achieving the vision which our framers of the Constitution desired at the time of 1949, and finally the conclusion part. So coming to the first part, that is the background. What are the circumstances? What was the situation at the time when the Constitution of India was prepared? So the first point is, we will go back to the history of India first. As you all know, at the time when there was a disintegration of Mughal Empire, the long ruling Mughals, their empire was crippling. It was coming down due to the rise of Marathas and other national powers. So at the time when there was a disintegration of Mughal empire, so that vacuum, that territorial vacuum was filled by the advent of Britishers in India. I would like to invite your attention to the year 1600 AD, when the Britishers, in the form of East India Company, they were the first one to come to India as traders. So the initial motive of the East India Company was to establish an identity, a kind of its tentacles in India as a trading entity. But gradually, with the passage of time, they emerged as a territorial and military power in India. Secondly, at the time when we witnessed the advent of Britishers in India, there was no entity like India. What you see in the present form, the complete political map of India, there was no entity like India at that time. As the entire Indian subcontinent, ranging from the regions of Afghanistan up to Sri Lanka, as the neighboring countries were also part of this undivided India. So the entire India was divided, was bifurcated among various princely states. And these princely states were existing as an autonomous entities, having no control of any central authority. So as we say that this is India, this is Hindustan, but there was no entity like India at the time when we witnessed the advent of Britishers, and at the time when there was a disintegration of Mughal Empire. Thirdly, the third major challenge which we must acknowledge here is the heterogeneous character of the Indian society. I will brief you what is the meaning of the term heterogeneous. You all know that India is a society which is not a homogeneous, which implies that, like America, Britain, their society is predominantly dominated by the existence of one religion, that is Christianity, one culture, one language. But on contrary to that, the Indian society is totally different. Here the circumstances are totally different because there is an existence of multiple languages, multiple castes, multiple races, their own cultural patterns, their own dialects. So it was not an easy task to unify all these multifarious religion, race, caste, languages into one nation. That was a very major challenge for the framers of the Indian Constitution. Even if you try to make a constitution for the entire country, but whether it will be accepted by all the members of the country, there is no surety. They may refuse that we are not going to govern by the central entity. We are not going to accept the existence of any central entity as we want our own independent status. So that was the situation prevailing at the time before 1947. Lastly, as you all know, after the acceptance of Mountbatten Plan of 1947, India was divided into two countries, that is India and Pakistan. And the Britishers decided to play a kind of a game that they granted independence to all the princely states, that whether you want to go with India or with Pakistan, it is your discretionary power. We are not going to impose anything upon you. Either you choose India or you choose Pakistan. So imagine the situation in 1947. On one hand, your country is partitioned, your country is divided on the basis of religious lines under the Mountbatten Plan. On the other hand, you have a kind of a reason to celebrate that yes, we are going to be independent. But the challenges lies ahead. What is the challenge? That is to maintain the sovereignty and territorial integrity of India. So you all know the credit goes to the efforts of Sardar Vallabhbhai Patel. So due to the master diplomacy he played, now even though I am calling it as a diplomacy, but it was a mixture of everything. That is to exert military operations wherever required, to exert, to leverage diplomacy wherever required, and to exert other kind of influences also wherever required. So due to that complete package of master craft, the India what we see today in the political map was finally unified and created. This was the situation. I would like to highlight one important military mission which is often disappeared in the textbook of history, what we saw in our school time, Operation Polo. Operation Polo was a kind of the most successful military operation of 1948, led by General Nathu Singh, who belonged to Rajasthan. So, in that operation, he successfully saved Hyderabad to be an hostile entity towards the Union of India, and finally, Hyderabad was amalgamated into the Union of India. The same situation occurred in Saurashtra, in the area of Kathiawar area of Gujarat. We also faced resistance of certain other princely states, but finally they all became a part of India. As you all know, the Balochistan is the largest province of Pakistan, which is very disturbed presently. That was the time when they were planning to amalgamate with India. They never desired that we are going to be a part of Pakistan. But due to certain mischievous tactics and diplomacy played by Muhammad Ali Jinnah, somehow it couldn't happen. So this was the situation as I highlighted, and the major task was to prepare a constitution which is generally acceptable to all, which should not act as a kind of a, or which should not give a message to the people of India that a certain kind of a document or a certain kind of culture is to be imposed on us. Consequently, they are not going to accept it. So we need to have a constitution which will be acceptable to all. Yes. So now I am going to deal with the historical perspective that how this entire journey developed, how the gradual development of Indian Constitution took place. As I told you, advent of East India Company as traders in year 1600, but gradually realizing the circumstances which were prevailing in Indian subcontinent, they were very smart colonial masters. because Britishers they specialized in having a colonial domination all over the world at that time. So when they perceived that proper, congenial, favorable circumstances exist in Indians' perspective that we can establish our territorial empire, we can control India in a way of military, in a way of territorial annexation, we must go for it. So gradually that East India Company, which we initially we saw it as a trading entity, it emerged as a territorial and administrative power in India. And the zenith, the peak of its emergence was the year 1765, when by the passing of Regulating Act of 1773, the Diwani rights implies control over revenue and administration. Diwani rights were acquired by East India Company for the region of Bengal, Bihar and Orissa. What you see on the map today, that has been bifurcated into three states. But earlier it was a part of a one state, that is state of Bengal. So Sir Warren Hastings, he was appointed as the governor of Bengal at that time. And thereafter, from 1773 up to 1857, various legislative enactments were passed by British Parliament with the objective to control their political and administrative control over India. They had the very sole and very clear objective in their mind that we are going to subjugate, we are going to conquer Indian territory and we are going to have it of dominant colonial rule all over India. So this entire journey commencing from 1773 up to 1857, so that was a herald of, that was a beginning of a kind of a legislative reforms in India. Because in the earlier concept, in Indian concept, we never had a law-making process like the Parliament of India, passing of act, resolutions. Our law-making process was like a farman issued by the king. Whatever is said by the king is the supreme sovereign law. This is the Western concept, like deliberations in Parliament of India or in a law-making body comprising of the elected representatives of people. You are discussing law, you are deliberating upon each and every provision of law, and finally, by majority principle, you are going to enact it. So, this entire process of 1773 up to 1857 that gave a new dimension to the law-making process of India. That is, enactment of law by following the legislative process, by following the parliamentary process of India. Then another landmark event occurred. That is, as you all know, you must have come across in your history books. That is the revolt of 1857. That was a turning point in the history of India. Now, we often characterize the revolt of 1857 as a military mutiny, but it was not. Its dimensions, its ramifications, its implications, its consequences were much bigger than just being a military mutiny. So, finally, that revolt was also suppressed by use of force by the British Crown, but they learned their own lessons. The British Crown, they realized that now to prevent the occurrence of a similar kind of event in future, what measures, what reforms we are going to initiate in India. So the very first thing, that is the abolition of East India Company. Now there will be no identity like East India Company. The British Crown assumed direct responsibility for the governance and administration of India. So earlier we had the Governor General of Bengal. Now he was recharged as the Viceroy of India. Okay. So there will be a supreme authority like a Viceroy for the entire Indian territory. Secondly, the British Crown assumed direct responsibility for the governance of India without having any kind of proxy agency. And thirdly, they stopped all their reforms which they initiated earlier in the field of education, in the field of social norms, in the field of sociology. I will give you one example. In our schools or in our colleges, we have two systems, that is school will be conducted for 6 hours or 8 hours, and we will have one principal. So this system was introduced by Lord Macaulay. This is a part of a British system that certain hours of our school, the period system, there will be one headmaster. So this entire scheme was prepared by Lord Macaulay as he was trying to introduce the British education system in India. So after 1857, the Britishers realized that we are not going to have any kind of interference, any kind of meddlesome interfering tendencies with the Indian culture. Let it be. We should not go for initiating any reforms. Secondly, they realized that the greatest strength of India lies in its unified society, as they fight as a one entity. So they started following the policy of divide and rule, which culminated further in the form of Parliamentary reforms or in the form of Government of India Act 1999, etc. Okay. So from the period of 1858 to 1947, various legislative acts were passed by the British Parliament. Multiple acts. For example, the police system, what you have today, that system was developed in 1843. The credit goes to Sir Charles Napier. So he was the Inspector General of British Police. He was posted at FATA. You know where is FATA in the present, in the today's context? FATA is the federally administered tribal areas, the Waziristan part of Pakistan. It is disturbed today and it was also disturbed at that time. So he realized that involvement of military is not a possible solution. We must have a separate entity for the maintenance of routine day-to-day affairs. And that is how the police came into existence. Thereafter, the Lee Commission of 1902 or the reforms of 1927, the Dharamveer Commission. So these all commissions and committees further refined, further bolstered, further strengthened that entire police system. So I am giving you this example to highlight that the administrative structure of India, the revenue system of India, the police system of India, the education system of India, this is all a result of inheritance from the colonial. This is not something which is devised by our own, because the Indian culture was totally different. The Britishers, they tried to change the entire system, and we are still continuing with a lot of things which were introduced by Britishers in India. So then I will come to the Act of 1909 and the Government of India Act of 1990. That created a kind of a legislative bodies. What you see, we have a Lok Sabha, we have Rajya Sabha, we have governors in the state, we have Reserve Bank of India. So all these reforms, all these institutions were created by the Government of India Act of 1919 as well as the Act of 1935. In fact, you will be surprised to know that the 60% part of the Indian Constitution, what you have it today, that comes from the Government of India Act of 1935. Like the institution of governor. So that institution of governor was created under the Act of 1935. We made certain changes and finally we reintroduced in the present draft of the Indian Constitution. The Reserve Bank of India, that was created in 1935. And there are n number of other features which were created by the Britishers and finally adopted by the Constituent Assembly in the today's Constitution. Later on, the period from 1935 to 1947, you need to understand the global circumstances. That was the period when the Britishers were confronting with the Second World War. So the majority of their military resources, the majority of their economic resources were occupied in dealing with the security challenges, in dealing with the frontier challenges. And that was the time when we saw that was the phase of India's national struggle for freedom of mass movement. You all know the Quit India movement of 1942. So there was a clear demand among the leaders of Indian struggle for freedom that we want Purna Swaraj. Earlier they were demanding the dominion status of India. Dominion status means that we will have a kind of a limited autonomy in our internal affairs, but ultimately we will be subordinate to British Crown. But now they change the stance. Now they want Purn Swaraj, that is to be independent in our own internal and external affairs without the control of any outside agency. So that was the time when it became indispensable, when it became unavoidable for the Britishers to have negotiations with Indian leaders. So they sent multiple missions, like the Cripps mission of 1942, the Wavell Plan of 1945, the Shimla Conference of 1945, in which they offered a kind of a pacifying, a kind of a placating deals to Indian leaders that yes, we are going to grant you a limited type of autonomy and that should be acceptable to us. But we refused. We said that we want complete freedom. We want Purna Swaraj. Now, one important event which is responsible for the that compelled the Britishers to leave India to grant independence. That has not been highlighted very much in the books of history. That is the naval mutiny of 1946. This is a very interesting event. In 1946, the naval units of British Indian Navy stationed at Bombay. So there was a major revolt against the British commanders. When this revolt occurred, the Britishers finally realized that the principal organ of maintaining control over Indian, that is their armed forces, if they are revolting, then the situation is very alarming. This is the right time that we should leave India and we should grant them complete autonomy. So the hidden heroes, the unsung heroes responsible for making the Britishers realize that you should go away from India, they were the battalion, the sepoys of the Royal Indian Navy who revolted against British commanders in 1946, December 1946. Thereafter, one important event comes, that is the cabinet mission plan. That the three ministers of British cabinet, they came to India, they carried out detailed negotiations at Shimla, and finally they agreed that we are going to have a constituent assembly which will be responsible for the drafting of the Indian Constitution. And this plan was accepted by the members of Indian National Congress. But another thing was going on, another territorial challenge was there. That is the rise of Muslim League, and they refused that we are not going to accept this constituent assembly. First you give us a separate nation called Pakistan. And we want to have a separate constituent assembly for our own country. We are not going to be part of this constituent. So the 1946, the formation of the Constituent Assembly, which is the body responsible for the drafting of the Indian Constitution. Now, how this Constituent Assembly worked, I will brief you. Yes. So, the Cabinet Mission Plan of 1946 and the acceptance of Cabinet Mission Plan is the formation of the Constituent Assembly. Now, going back to the year 1934, this term Constituent Assembly, this was used for the first time by M.N. Roy, who was a pioneer personality in having a democratic movement in India. So he was the first one who proposed that we must have a Constituent Assembly and we should have a constitution which is drafted by our own Constituent Assembly and which is not imposed by any British policy makers. Okay. So after the formation of Constituent Assembly in 1946, the bigger challenge is how to compose it, how the members should be elected. So the total strength of the Constituent Assembly was 393. So out of which 293 members were to be indirectly elected from the autonomous states. That is the states which were under the control of the Britishers. I am talking about indirect elections, not directly elected by the people. And the remaining seats were to be filled by the representatives of the princely states. And they are going to nominate. That, for example, in Rajasthan, which is known as Rajputana, there were multiple princely states. So each state, in proportion to their population, they nominated 1, 2, or 5 members for their representation in the Constituent Assembly, and thereafter this assembly was composed of 5. Then you all know 15th August 1947, the day when independence was finally given to India, but at the cost of losing territory because the partition was also announced by the Lord Mountbatten, who was Viceroy of India. Okay. Now finally this partition plan was also accepted. That is a different story, not relevant in the present context. Now after the independence of India, the major challenge is how to draft a constitution. First of all, to unify the territory so that we can have an identity called India, and thereafter to draft a constitution which is acceptable to all the parts of India, all the states of India. There should not be the circumstances where there is a kind of a dissatisfaction, where there is a kind of a revolt in any part of India. So, this Constituent Assembly was divided among different committees. For example, as we all know, the most important committee was the drafting committee headed by Dr. B.R. Ambedkar. But in addition to that, there were multiple committees, like Committee for Fundamental Rights, Committee for Determining the Governance of India, Committee for Determining the Election Process of India, and each committee was headed by a different personality. Now the one important event, that is of, as I mentioned, the objective resolution of 1946. So in the very initial meetings of the Constituent Assembly, Pandit Jawaharlal Nehru, he moved one objective resolution on December 13, 1946. Now as clear by the name itself, objective resolution. So this resolution highlighted the nature, the character, and the entire shape of Indian democratic system. Now, the identity, the ideology, and philosophy of Indian Constitution is entirely based on the text of this objective resolution. So, two important things. One, it laid down that the ultimate source of power, the paramount authority, will be the people of India, not the political class. And secondly, India is going to be a welfare state. It is not going to be a capitalist state. So welfare state implies existence of prominence of socialism in Indian democratic perspective. So this is how they conveyed what will be the basic framework, what will be the basic ideology for the drafting of the Indian Constitution. So from 1948 up to the day of 26th of January 1949, intense deliberations, very detailed discussions held among the members of all the members of the Constituent Assembly, and finally the draft was prepared. The final draft was prepared, as I said, after intensive deliberations lasting for a period of 2 years, 11 months and 18 days. That now, okay, this is the final draft of the Indian Constitution. Now, while preparing the draft, various considerations were in front of the policymakers. One is the peculiar circumstances of the Indian subcontinent. Secondly, we referred to almost all the established constitution of that time. That is Germany, that is America, Britain, Canada, Australia, South America, because certain fundamental principles were ready in front of us. I will give you one example. Like we have a parliamentary form of government. So this system of parliamentary governance is not created by the framers of Indian Constitution. It is adopted from the British Westminster model. We have a concept of federalism. What is federalism? That is distribution of power between the center and states. Right? For example, you all belong to the field of education. Now, education is the subject in which center as well as states, they both are empowered to make their policies and laws. So that comes in the concurrent list. So now this entire scheme of federalism was taken from the Constitution of Canada. You have a Supreme Court of India, you have fundamental rights. So these features were borrowed from the Constitution of America. So the Indian Constitution was drafted, it is having various borrowing features taken from all over the world. So after such detailed deliberations, the final draft was adopted today, that is the 26th November 1949, and that is how we celebrate it as a to commemorate the memory of the Constitution. And thereafter, certain provisions of the Constitution of India came into force on the day of 26th November 1949 itself, and the remaining provisions were finally enforced on the day of 26th of January 1950. So this is how the drafting of the Indian Constitution took place. Now, I will give you the basic idea that how the Indian Constitution was organized. So the very first thing, that is the preamble, as we just read. So preamble, in the words of Nani Palkiwala, a very renowned lawyer, he said that preamble is the identity card of the Indian Constitution. Identity card means just by reading the preamble, by a mere perusal of the text of preamble, you will come to know that what kind of democratic system India is going to have. These 5 words, which I will re-emphasize for your convenience, that is SSSDR, Sovereign, Socialist, Secular, Democratic Republic. So this is the identity of the Indian political system, the Indian democratic system. Okay. So preamble, the word itself implies a kind of an introductory statement, which is an essential part of the Indian Constitution. Thereafter, the Constitution of India was organized, divided in various parts. Part 1, those parts were subdivided in articles, Article 1, 2, 3, 4. And in addition to parts and articles, we have schedules attached with the draft of the Constitution. So initially, at the time when the Constitution of India was enacted on the day of 26th of January, we were having 395 articles and 8 schedules. Now the situation is different. Due to frequent amendments, now we have more than 443 articles and 12 schedules. Because due to changing circumstances, due to the changing socio-economic scenario, multiple amendments were carried out in the draft of the Indian Constitution. Okay, so this is how the organization was carried out. Division of Indian Constitution among parts, articles and schedules. That is how they organized. Secondly, you need to understand as a citizen of India, keeping aside the procedural governance aspect, the basic rights which are given constitutional recognition under the document, that is your fundamental rights. Now, as you know, fundamental rights, fundamental itself means your elementary rights. Now, I would like to highlight one thing here, that these fundamental rights are not created by the framers of the Indian Constitution. These rights were existing before the enactment of Indian Constitution. They just gave a kind of a constitutional recognition to these rights. For example, we all have a right to education, which is a part of right to life. We all have a right to equality. So these rights were given constitutional recognition by the framers of the Indian Constitution. Now these rights are, some rights are available to citizens of India and some rights are available to all the persons, whether you are citizen or whether you are non-citizen of India. Now to illustrate, for example, you have a protection against arbitrary arrest and detention, that the law enforcement agency cannot make an arrest of a person without any reason, without following the due process of law. So now this right is available to non-citizens as well. This is not exclusively for the people of India. Why? Because we have at international level, we have another document, that is UDHR, Universal Declaration of Human Rights, which is often considered as a Magna Carta, the fundamental document. So it lays down certain human rights which are very similar to the fundamental rights as enshrined under the Indian Constitution. So they are your basic rights from which no derogation is permitted. No government, no agency can make a law which is inconsistent with or which is violative of the fundamental rights as guaranteed under the Constitution of India. Okay. Now, after 1950, as on many occasions, we witnessed that there was a kind of a upheaval, there was a kind of a turbulence, a very chaotic situation occurred in the at the Indian political scenario. That is the imposition of president rule for personal reasons, for political motives, the fall of government, elections, re-elections. So the constitution was keep on modified by the political parties, which is suitable to their personal motives. For example, in the year ranging from 1972 to 1978, the president rule, that is, when there is a failure of constitutional machinery in the state, the center imposes president rule under Article 356. Unguided, this provision was misused by the prevailing government at that time simply to achieve its political objectives. So this created a situation when there was a threat to the political, to the constitutional system of India. That tomorrow it may be possible that you may change that the tenure of a government will not be for 5 years, it may be for 10 years. So if such type of unguided, absolutely abusive discretionary power is granted to the parliamentarians, then they may change the entire nature and character of the constitution, which our framers never desired. They never had such thing in their mind that this document should be misused as per your political objectives. So the landmark event comes in the year 1973. There is one case law which is supposed to be the very important case law, a 1300 page document known as Keshwananda Bharti versus State of Kerala. So at that time, 13 judge bench of the Supreme Court, they presided in the courtroom number 1 of the Supreme Court of India, and they considered multiple aspects of the Constitution of India. And the outcome was, after a very detailed day and night hearing, continued for more than 45 days. Finally, the concept of basic structure came into existence. Now, what is the basic structure theory? The Supreme Court propounded the law that the Parliament's power to amend the Constitution is not absolute, but it is restricted. It is subject to certain restrictions. It cannot be exercised for any kind of ulterior, bona fide reasons. It should be guided with the principles of constitutionality and the ideals of the preamble. So, as per the basic structure theory, the Supreme Court propounded the law that the basic structure of the Constitution cannot be amended by the Parliament. So, what is the basic structure? Like the existence of rule of law, the existence of democratic system, free and fair election. So 9 to 10 features were laid down which are not subject to the amendment, the Parliament power to amend the Constitution under Article 363. For example, tomorrow if there is an amendment before the Parliament that we are going to abolish the Supreme Court of India, is it possible? Why it is not possible? Because the existence of an independent, impartial judiciary is a part of the basic structure of India, which can never be violated, which can never be altered, which can never be amended under any circumstances. Those basic structure theory is paramount. It is sacrosanct. It is not subject to any kind of review by the Parliament. So this is how this basic structure theory was propounded, and the basic ideology, the basic bulwark of the Indian Constitution was protected by the Supreme Court of India. Yes, next is the salient features of the Constitution. There are multiple features, but I will be dealing with a few important aspects. The first one is lengthiest document and borrowed features. You should know that if you see the Constitution of America, it is a very short document. you will not find the existence of 100 articles, 200 articles. Or if you refer to the constitution of other countries like Australia, South Africa, so they are very brief documents. But on the contrary, the Indian constitution is the lengthiest constitution in the world because they laid down everything in detail. They codified everything in the forms of articles. We have, as I told you at the beginning, we had existence of 395 articles and 8 schedules. So that made it the lengthiest document, the lengthiest constitution in the world. Secondly, the borrowed features. As I briefed you, we have various borrowed features. Personally speaking, it is a subject of criticism in my view that you created a constitution which is not an outcome of your own application of mind, but you borrowed certain features from the other constitutions and you implemented it in the Indian perspective. Now, it may be possible that the Indian society is not suitable to be governed by those aspects. What is successful in America that can never be applied in India because the social perspective, the economic perspective, the political perspective is entirely different. They have a different type of society, but still we have more than 80% features of text and content of the Indian Constitution is borrowed from some source. One is the most important is the Government of India Act of 1935 and other constitutions of the world. Secondly, the blend of rigidity and flexibility. Now, the framers of the Indian Constitution, they were aware that if we create a kind of a document which is very rigid, rigid means something which is very difficult to change. So with the passage of time, its utility will be totally diminished. It will have no use. It will become totally obsolete because due to the change of socio-economic circumstances, perspectives, the situation may come which require the constitution to be amended. So they provided a very simple procedure of amendment. But on the contrary, in order to prevent the abuse of the amending power of the parliament, they also provide a rigid procedure for amendment for the amending certain specific features. Like certain amendments can be done by simple majority of parliament, but for certain amendments you need to have two-third majority of parliament as well as ratification by half of the states. So that is very difficult to adopt, to implement in a pragmatic situation. I mean, you will not have political government in one half of the Indian state, so they are not going to ratify that amending bill. So this is how they created a blend of rigidity and flexibility. Third one is federal system with unitary bias. As I explained, what is the federal system? That is distribution of powers among center and states. But in emergency situation, when there is an imposition of emergency on the ground of war, external aggression, armed rebellion, or financial emergency, the central government, the Parliament of India, they become supreme. They will have complete lawmaking power for the entire territory of India. So even though we do have a federal system, but with a unitary bias. In certain special conditions, the Constitution of India, the political structure of India may become a unitary, centralized in nature. Parliamentary form of government, you all know that the ultimate source of power in the Indian context is the people of India. Because at the end of 5 years, election occurs, and with your vote, you have a right to choose your own government. So neither the constitution is supreme, nor the political power is supreme. The ultimate authority lies with the people of India. They have the power to choose their government and to decide who will be their representatives in the Parliament of India. Then the directive principles of state policy. Now, if you refer to Article 36 to 51, there are certain directive principles. So basically, these are the directions which are fundamental to the governance of the state. These directive principles are mostly socialistic welfare provisions. For example, you have a provision for equal pay for equal work. Now, this is the directive given by the Constitution to the policy makers that when you prepare your policy, you observe these directions, as these directions are enshrined under the constitution to have a kind of a socialist welfare state, that no one should be subjected to any kind of discrimination. So the government is bound to observe these directions while framing their own laws. Then we have a three-tier government. You know the meaning of three-tier government, that is central government, state government, and now we have local self-government in the form of nagar nigams, panchayats, that is called the local self-government. So with the objective to decentralize the power, with the objective to expedite the equal distribution of economic and other resources, and a participative decision making which involves the aspirations, the wishes of the people, a three-tier system of government was created by the Constitution of India. At the last, we have universal adult franchise. That is, right to vote is given to all of you, to all the citizens who are above 18 years. So you can exercise your right to vote in order to decide that who will be your representative in the legislative bodies as created by the Constitution of India. So these are some of the essential features of the Constitution of India, which makes it a very unique document, which ensures a participative democracy, not a kind of an imposed democracy. Now, coming to the last part, as we are in the year 2024, so we must have a critical evaluation. Whether are we successful in achieving the objectives as desired by the framers of the Indian Constitution? In my personal opinion, no. Because we must have a critical review of the Constitution of the entire political entity also. The first important is, as I said, objectives are not achieved yet. As I told you, the Constitution of India is a document which comprises of various borrowing features. Now, those borrowing features are mostly Western concepts. They are not Indian concepts. So, it is not a guaranteed thing that something which is successful as a model of governance in Western societies, that will have the same rate of success in the Indian context. Because our society, the level of education, the awareness about their rights, about their duties, that is totally different from American societies, from Western societies. So, if we analyze it today, the Constitution has just become a kind of a theoretical document, whereas the practical situation are totally different. Equal justice, fundamental rights. So that is everything. It cannot be assured, it cannot be guaranteed to all the citizens in equal way. There will be loopholes. There are circumstances where the constitutional protection is not available to all the citizens of India due to the magnitude of population, due to scarcity of resources. As you see that our courts are highly overburdened. There are n number of cases pending before the court. We often say, in the words of Justice Krishna here, justice delayed is justice denied. But this rule has been flagrantly violated in all the courts of India. You also witness that incompetent judges are being selected in the present scenario, who are far away from having a good understanding of law, and ultimately the litigant, it manifests in the poor justice in the society, and that is how the people are compelled to take the law in their own hands, because they are not having any relief from the state institutions. So ultimately it will create a kind of lawlessness in the society. So if we make a critical evaluation today on the day of 26th of November, we will have mixed opinions that yes, up to certain extent, Constitution of India was very much successful in protecting your human rights, in having an orderly society, but still the objectives which the framers desired to be achieved have not been accomplished in totality. We are lacking in certain aspects. Now, finally, as a conclusion, we must say that even though with defects having merits or demerits, the Constitution will always be the fundamental law of the land. Fundamental law of the land means the supreme law of the land, from which no derogation is permitted under any circumstances. Constitution of India is not a sacrosanct cow. This is not a God-made document. It may have certain own merits, demerits. The changing circumstances may require that we should have certain kind of changes in the constitution, but still we regard it as a fundamental law of the land. Under any circumstances, having whether good motive or bad motive, the state is not permitted from making any derogation with this document. Secondly, the Constitution of India unifies the people of India in a way, and it provides a standard guideline to the political class of India. It was very much successful in keeping a check on unguided discretionary power of the political government. Because when you have a standard set of rules, when you have a standard set of laws, so that set a yardstick of formula to adjudge and declare that whether your actions are right or wrong. It is the cornerstone on which the actions of the executive machinery or the actions of the administrative machinery will always be subject to evaluation. And lastly, as I said, we have given due importance to the fundamental rights, to the human rights of people. So, the Constitution of India was very much successful in protecting your own fundamental rights and human rights. But on the contrary, it also assisted the people who does not deserve to have human rights, like the antisocial elements. They are also taking undue advantage of their constitutional rights. Because you all know that in India, the conviction rate is very poor. For example, out of 100 criminals, only 19 are punished and 81 will be exonerated. Why? Because the kind of system you have created, so the 100% a watertight approach is not possible. There are always chances of loopholes, like decay of evidence, delay in trial, lack of scientific evidence. So that benefit is always available to the criminal part. The Indian philosophy says that the burden of proof lies on prosecution. And in the recent modern jurisprudence, the Supreme Court has diluted the entire criminal law and has taken away all the weapons and defenses of the prosecution. So, the state is not ready to believe its own law enforcement agencies. Something which is produced by police, something which is produced by a law enforcement agency, that is subject of review. The court will not believe it unless and until it is proved beyond reasonable doubt. Now, this phrase, beyond reasonable doubt, is a very vague. There is no formula. It depends on your personal satisfaction that what is considered to be beyond reasonable doubt and what is considered to be a circumstances in which benefit of doubt is given. So ultimately, this is going to benefit the antisocial element, the criminal elements of society. I again say that whether it is a Constitution of India or any law, the first priority is to maintain the territorial integrity of India. If you don't have a territory, if you don't have a country, then there is no utility of any constitution. The constitution exists only when your state identity is protected, when your territorial integrity and sovereignty is protected from external disturbances and elements. Thank you.